Welcome back to the Crypto's Key Conversation. Throughout this video, we're going to be going over Johnny Deaton's thread where he's talking about the biggest decision in the Ripple case. So there's a huge milestone going. On a little side note, this is actually the 100th video for our channel. So, just as the Ripple versus SC case has a milestone, this channel hit a milestone. So I appreciate you guys being here supporting the channel. Quickly going over CoinGecko here. We're currently sitting at a $1.86 trillion market cap, currently up 2.5% for the day. Coming down here to the top 10, Bitcoin sitting at 39,149, Ethereum sitting at 2,744, Tether's Tether, Binance Coin sitting at 382, XRP sitting at 78 cents, Cardano sitting at 96 cents, Solana's at $91, Terra's at $52, and Avalanche is sitting at $79. Coming over here to the Bitcoin Fear and Greed Index, we're back in this extreme fear range. So obviously we have Jerome Powell and the Fed and inflation, interest rate hikes, just the uncertainty with, their plan of attack, whether they're going to be super dovish or super hawkish or not. And then you have, tensions with Ukraine and Russia and just a lot of FUD and fear articles that's been surfacing out in the community. So there's so much uncertainty in the market, which is kind of keeping us down at this level. But coming into the topic of discussion, Johnny Deaton had a great thread talking about the biggest decision in the Ripple case. So he starts by saying, Judge Netburn's decision on the motion for reconsideration will be the biggest decision in the Ripple case. I say that because I don't believe the motion to strike the FND is a significant one because the judge isn't deciding whether Ripple had fair notice, but only whether it can argue it. Coming down here, it says, the reconsideration motion released to the 63 emails containing the drafts and comments regarding the Hinman ETH is no longer a security speech. The final version of the speech discusses both Bitcoin and ETH. The final version does not refer or mention XRP. XRP consistently battled ETH for the number 2 crypto behind Bitcoin in January 2018, 6 months before the Hinman speech. XRP hit an all-time high above $3, making it world's second largest crypto. What are the chances of XRP not being raised at all in any of the 63 emails? What are the chances that at least one person in the email chain brought up XRP? One person in the email chain could have passed a very reasonable question such as, what about XRP? He continues down here, he says, once someone understands how ETH was created and utilized and how XRP was created and utilized, it becomes very logical to ask. For example, attorney Wendy Moore, a partner at Perkins Coie, a law firm very knowledgeable of both ETH and XRP, asked that very question. So we brought this up, so let's take a listen in real quick.
The division director said it's decentralized. So, hey, look at the metrics for Ether. And, hey, you do a little better than that, hey.
Then why isn't Ripple?
Yeah, and I wonder if they had...
So coming down here, it says, to be blunt, once you understand both ETH and XRP, it's impossible not to ask that question. Joseph Grundfest, who helped the Ethereum founders explain this to the SEC in December 17, 2020 letter. The Perkins Coie lawyers who advised both platforms raised the same question. It's fair to assume that XRP was brought up in one of those emails. We know that on June 13, 2018, a memo analyzing whether XRP was a security had been completed and did not recommend enforcement. If true, the mere fact that XRP was mentioned in an email is exculpatory. If Judge Netburn ultimately rules that the emails must be turned over, it is huge. Don't forget, even if the SEC persuades her that the emails are covered under the DPP, which they totally will, she can still pierce the privilege and order the documents produced. At that point, I guarantee we don't see it. There'll be a settlement. I mean, that's what I'm thinking at least. If she rules the emails privileged but orders the SEC to produce them, it means XRP is referred to and or the evidence is indeed exculpatory. If the judge believes evidence is exculpatory and Ripple has no other means of obtaining the evidence, she will pierce the privilege, which would be absolutely massive. If she overturns her previous ruling and decides that the emails are privileged but doesn't pierce her privilege, the emails, although helpful to Ripple, are likely not to be as are likely not as big as we perceive. The reconsideration will be the biggest decision in the case, short of depositive motions. So I wanted to end on this too. This gentleman, Brian Monarch, had a question. He says, when asking in our Telegram room earlier if Ripple has all this obvious leverage and they've known about these powerful sealed docs for months, why haven't they told the SEC, hey, if you don't settle by the end of the month, settlement is off the table. Time is money. Johnny Deaton says, Ripple doesn't have the leverage yet. The SEC hasn't been forced to turn over. The judge ruled they were relevant twice. then ruled some of the some are privileged and the emails in certain meeting notes are not. But SEC is re-arguing the emails. The leverage hits when SEC must turn them over. So yeah, quite interesting. It's gonna be interesting to see what happens. My personal opinion, I mean, quite honestly, they don't obviously want us to see that. So I think if they're truly forced to turn them over, I can definitely see them, trying to pull some sort of settlement out of their butt to kind of suppress the truth. Because who knows what we're gonna, as digital asset investor says, and I think it's great. He says, what breadcrumbs are we gonna find throughout those emails? How that the crypto army and the XRP army, once that's all surfaced and it's known, everyone's going to be out there just digging for more information based on the information we get from those 63 emails, and it's just the reality. So I doubt we see that. But moving on, he's responding to a tweet from Bill here. Says, I note the XRP called Ripple is described with Litecoin and Bitcoin as decentralized in one slide. This was 2013. That was the Perkins-Coie view, not inconsistent with the 2012 advice. How much more was it decentralized by June 2018? And then Johnny Deaton says exactly the point here. If XRP was ever an investment contract with Ripple, it would have been most likely one in 2012. Yet the legal conclusion was that it was not. As each year passed, the XRP ecosystem grew and XRP became less and less of an investment contract of Ripple's. And then XRP Crow right here pulled up the ecosystem back in 2019. Obviously, we know it's absolutely massive. Some of this stuff may be off of here, but this is absolutely massive now. Coming down here, there was this video right here. This is our current chairman Gensler, but early adopter had put this video up. Let's take a listen into this.
Strong, highly volatile. It peaked at about $800 billion in January. It's been settled around 200 to 300 billion. A little over half is Bitcoin, 55% or so in that slide. But Ethereum is quite big. A currency called Ripple that you might hear in the banking sector is a currency called Ripple. A currency called Ripple.
A currency called Ripple. A currency called Ripple. Get over here!
I thought that was hilarious. I mean, that just this face right here, like hold up, I got you. Boom, decimation. Let me drop this lawsuit in your lap. I mean, that's what they did. This was days before Christmas in 2020. Jay Clayton and the parties that were backing him literally just laid that in Ripple's lap and then all XRP investors' lap, just decimating kind of our plans when it comes to our XRP investment, even though we had no ties to Ripple. It's crazy. Moving on here, Johnny Deaton's responding to a tweet from Martin Volk that says, this XRP news. Ripple CEO says the truth is finally out following unsealing a 2012 legal XRP memos to the public. So we were talking about Stuart Alderati, who's Ripple's general counsel, how he was talking about the information they got from that third party was that, or Perkins-Coie, was that it was not considered an investment contract and XRP was not a security. So Johnny Deaton says, if this case was about enforcing securities laws in a fair and impartial manner, the case would have settled a year ago. Ripple would agree to pay. Blank related to the sales of XRP between 2013 and 2017, with the SEC agreeing on ongoing and future sales of XRP are not securities. I mean, yeah, I think that's quite evident. Coming over here, there's just this article that says XRP is not a security, says ex-CFTC chairman. So they're talking about Christian Carlo, and they had an interview with Charles Gasparino, and we pulled up the video on our past videos, but I'm gonna come over this quote right here. It says, Christian Carlo replied, before the SEC launched its enforcement action against XRP and Ripple, I pinned an op-ed in which we applied the same approach we would have taken when I was at the CFTC. We analyzed XRP token under the Howey test, and we came to the conclusion that in 2020 article that it was not. Let me highlight this. It was not a security, and I stand behind the article today. So when we were watching the video, Christian Carlo didn't, in respects to, his former position and those that are in current office right now, he didn't want to overstep the judge's toes or, the other, people in office toes. He was saying, I pretty much, he said he didn't want to what do they call it, Monday quarterback it, pretty much, where he's like kind of acting like, if he, because he's not in it, he's gonna, just formulate his opinion on how things should go. He was just saying like, hey, here's kind of, here was my view, my understanding when I was in, but like now, it's in litigation right now. The judges obviously, they know what they're doing. I can't really speak on that, which I highly respect it, but clearly it was not a security. So if it was a security then, it's definitely in a security now. So coming over here, Jeremy Hogan, if you guys haven't saw Jeremy Hogan's recent video with his wife, make sure you go to Legal Briefs on YouTube and check it out. But he says Perkins Coie wrote the legal memos for Ripple back in 2012. Perkins and Coie assisted him in draft his 2018 Ethereum is no longer a security speech, so the Ethereum Free Pass speech. The Perkins and Coie website then posts the other senior officials and the chair of the SEC are in growing consensus among SEC officials. So coming down here, he says, strange coincidence. But my wife looked at this at this afternoon and thought of something I hadn't thought of. That the guidance Ripple followed back in 2012 is perfectly in line with the Hemin speech. She then argued it so well that I made her do a video with me. Poor thing. So if you haven't checked it out, make sure you go into Legal Briefs on YouTube and check out Jeremy Hogan's video with his wife, Tinfu. I think that's how you say her name. Sorry, guys, if I got that wrong. But yeah, they crushed the video. XRP Crypto Wolf down here says, if Ripple would have paid off the SEC like the Ethereum founder, then I have a feeling the XRP lawsuit would have never happened. So moving on here, Stefan Huber had a great tweet here. So he's talking about this. It's happening in a conversation with Ethereum's Joseph Lubin. I think we'll probably be able to use the I word at some point soon without being incarcerated. So this was November 25th, 2018. This is an article right here. And in here it says, some of our friends from the SEC are acutely aware that the certain people who are basically shut out of investing in good projects shouldn't be shut out. So some of our friends, now he says, folks, you will not believe it. You can't make this up. In November 2018, Lubin is even talking about his friends at the SEC, friends who will soon allow him to use the I word, investment, as well. Unbelievable. So then the source is down here. It's popula.com. So, I mean, for those that's been following kind of what's going on in the case, a lot of this stuff has surfaced. I want to thank Stefan Huber for putting this up, but we know that, Joe Lubin's involvement is super heavy within this whole Ethereum Free Pass, secrecy stuff behind closed doors, getting Bitcoin and Ethereum out of securities laws and slamming the door on, all the other projects. We all know that it's a part of it. So we're just going to continue to follow the case and see what happens. Eleanor Terrett's tweet here, I wanted to end with this one. It says, both Ripple and XRP have been trending interchangeably since Thursday. Things that make you literally just go, wow, what is about to happen? XRP Crypto Wolf says, XRP Army is one of the biggest communities in all of crypto and the smartest. Can't wait until XRP is unleashed. What excuses will the haters have then? This is from Von Redbird. So here's my thing. I don't know if you follow Kevin Cage, but I like Kevin Cage. And one thing he says that I truly agree with is like, when XRP takes off, not if it takes off, when it takes off, don't call us lucky, because we've been accumulating for years, riding all the ebbs and flows, the ups and downs, the good and the bad, just knowing that XRP was one of the so-called most hated cryptocurrencies within the crypto market, because it's the so-called bankers coin. It's like, we've been through all that, so don't call us lucky when this thing takes off, and a lot of us are well off from it, and I truly believe that. So both Ripple and XRP have been trending interchangeably since Thursday. Something's heating up. With all that being said, stay strong out there. Be safe.